Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. It's another Saturday. We are here with you on the program, The Community and the Law, live on BWTV. This afternoon, I have a very important question to pose to my resource person, Lawyer Charles Asma. And I'm going to ask, am I due for indefinite leave to remain? Then I'll follow up with the question, how do I know? Maybe you have the answer and you want to share your experience with us. I would want to get you involved. But please, let's sit back and enjoy whilst we have our Community and the Law program brought to you by BWF Solicitors, live on Facebook and YouTube at BWTV and at BWF Solicitors. My name is Oreku Frimpong. Let's get into it together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
We are officially in spring here in the UK, and we're excited that temperatures are rising and we're getting into double figures. And with that, we have the real feel good factor to work with when it is that we come your way every Saturday afternoon. A warm afternoon to you, wherever you find yourself. My name is Oreku Frimpon, and I'm here to bring you the program, the community, and the law under the auspices of BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors are legal firm persons here in the UK, and they help us with mostly immigration matters. They help us to understand the law. They keep us updated when it comes to all legal matters here in the UK, and also advise you when it is that you want to set up your business and you want legal representation. And by that kind courtesy, we bring you an update of what has happened in the week. And this week is no exception. We are going to have a very lively discussion on the topic and, of course, the questions that I posed earlier on. Do you know when you're due for indefinite leave to remain? How do you know? What are the things that you need to look for? And if it is that you do, what do you have to do? Can you just ignore it for the sake of it? Or you may have to take one or two steps to make sure that things are done right for you. That's what we're going to look at this very afternoon. But I would want to join all my Ghanaian brothers and sisters, and I invite all of you in the diaspora and here in the community to say Happy Independence Day to Ghanaians here in the UK and all over the world. Yesterday, the 6th of March, 2026 was the 69th independent anniversary. And BWF Solicitors say we celebrate the courage, unity, and resilience that shaped the nation. May the spirit of freedom and justice continue to guide all we do. Happy Independence Day to all Ghanaians, and we salute you. And I know you guys will definitely go by your national anthem. God bless our homeland, Ghana, and make our nation great and strong, bold to defend forever the cause of freedom and of right. And you continue to pray, fill our hearts with true humility, make us cherish fearless honesty, and help us to resist your precious rule with all our will and might forevermore. Salute all Ghanaians. Happy independence to you. And I believe that come next year, when you are 70 years as an independent country, be massive celebrations all over. So to Her Excellency Sabah Zita and members of government here in the UK, to the Ghanaian community, the chiefs, the people of the clergy, and everybody in the community, I salute you and wish you the best. Happy independence, Ghanaians. BWF Solicitor serves so many clients, and most of them are so very grateful and would want to provide some feedback to tell the world what it is that they have had from BWF Solicitors. And Frank is one such person. And Frank is saying that BWF Solicitors are solid, professional, and a courteous team. Leadership sets a strong example and it shows in their hard working approach. They keep clients fully informed and make every interaction straightforward. And he continues to say, I am truly grateful for the invaluable support they offer in our community and would wholeheartedly recommend them. Frank, thank you very much. That's so very kind of you. Very kind words. And it also tells the community what BWF Solicit does. And I believe that people would want to definitely go on and enjoy their service. BWF Solicitors are trusted partners when we come to the law. Well, they give us the service, yes, and they provide us with updates as well. On the 5th of March 2026, this was put out in the public domain. Migrant English language requirements become more demanding. From the 26th of March 2027, the English language requirement for settlement will rise from B1 to B2 across a broad range of immigration routes. BWF solicitors want to say that they would want to advise that those applying for settlement after March 2026 must now make every effort to take the English language lessons in preparation for the changes. Um, I believe that there would be a bit much more about what this is all about. We've looked at some dates here: 26th of March 2027 and March 2026. We're looking at English level B1 and B2. What's the difference? Um, why would they have to go higher? Maybe there's an explanation to that. And I probably would continue to ask, if I have B1 already, do I have to worry about anything when it is that I am putting in my application after March 2026? Ladies and gentlemen, with that, let me do some quick housekeeping and say that we are live at BWF Solicitors on Facebook and YouTube, at BWTV, Facebook and YouTube, and live on BWTV. My resource person and guest is Lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Brakoku.
Hi, you're proudly Ghanaian.
Happy Independence Day.
Same to you. How are you doing?
It's a pleasure. I'm doing well. Thank you.
We thank God for all the mercies He has shown us. Well, on the behalf of VWF solicitors, I've wished our clients, our viewers, and the community happy anniversary, 69 years. But then we hit with this update that came up on the 5th of March, 2026. And it's talking about the fact that from the 26th of March, 2027, English language requirement will rise from B1 to B2 across a broad range of immigration routes. What's happening?
Okay. Yeah. So I think the good thing is that it says from,
Mm,
and even though there are two dates there, the principal date is 26th of March 2027. So 1 year.
okay.
So from now till 25th of March 2027, you don't have a problem. The same approach will be followed through with English A2 or
Okay.
yeah. But the government is trying to make sure that English language proficiency is at A level standard. And with the A level standard, it means that you should be working at B2. B2.
Mhm.
So all those who are not there yet, if they are making application for indefinite or they are making application for any other, depending family life and so on and so forth, if you need English language, you are supposed to go through what it is at the moment. But from next year, March 2027, 26th, any application that requires English language, you have to make sure that you are working at B2. What is
Now,
happening?
if we are to break it down a bit more, B1, B2, I am thinking and I'm assuming that having gone to B, then definitely there will be an A level. What are the differences?
Okay. So A means the basic.
Okay.
Z means the super super. We don't have up to Z. We have up to C.
Okay.
A is primary school level.
Okay.
So A1 means primary school first part. Primary 1, primary 2, primary 3, primary 4.
Hmm.
So if you are working at A1, it means that you are primary school class 4 English. If you are working at A2, it means primary school class 5 and 6. And maybe secondary school year 7, or if it is other countries, junior high school 1. Then we go to B. B is secondary school and
Hmm.
A level. So B1 is up to secondary school level completion.
Okay.
In the UK, we say GCSE. In other countries, we say SSS. or SHS. In other places, we say high school. So if you're working at high school level or SSS level or GCS level, then that is secondary school standard of English speaking listening.
Mhm.
And if you're able to speak and listen at that GCSE or secondary school level, English language, then you are also able to express yourself in writing and in
Okay.
reading. So that is secondary school. Now the government is saying that we want people to be able to express themselves in the English language up to college level, college.
Okay.
So it is no longer up to secondary school level, but college, A level, and that is B2. Somebody was, what's the difference between college level English and secondary school level English?
Yeah.
It's just a matter of asking me, can I use my secondary school qualification to find a job? Is it better for somebody to use college qualification to find a job than school certificate qualification? Yes. The same way, asking somebody, should I use my degree qualification or my college qualification if I'm looking for a job? Which one will you advise? Degree qualification, isn't
The
it?
higher one of all.
The understanding is that you might have understood your cognitive, your reasoning, and all these things are up to a higher standard.
Okay.
And so if it is B2, then your appreciation of English language, the literal expression, the written expression are of much higher level compared to before.
Okay.
And that is a bit also making you able to function within the community in terms of expression.
Lawyer, functioning within the community, I was going to come to that point. The whole idea is for people to be able to function properly within the community. So they should be able to speak basic English, understand certain instructions, and within certain professional settings, be able to function properly. A1, 2, or whatever, up to B1 should have sufficed. Why are they increasing it? They're making it a bit more complicated, isn't it?
It's a policy matter. Have we asked ourselves, why is it that the government within the local authorities have made places which used to be 30 miles per hour, 40 miles per hour, they've made it 20 miles per hour?
Just to increase the level of safety?
Increase the level of safety. So if expression in English should be such that people can understand each other, people will
Mhm.
be able to function at the workplace, people will be able to function at different places within the community to make them productive and relevant. Then it's also about safety matter, isn't it?
I guess so.
And so, if you're able to understand it better and you can understand health and safety procedures, if, let's, for example, you are a care worker, you're able to
Mhm.
understand drug administration, drug reporting, and all these things because it's writing, it's reading, it's speaking, and stuff like that. The less proficient you are, the higher the risk of making mistakes. And
Okay.
so, the government is saying that for policy reasons, we are raising the bar for English language proficiency so that people can function properly. Then it becomes a policy matter.
So there are dates, I think you mentioned it earlier on, from 26th of March 2027. So between now and next year, when we enter spring, so to speak, we will be able to function properly at B1 and probably below.
Yes. Well, it says B2, right?
Yeah, so it says it's
Oh, from
rising
now, yes.
from
From
B1
now
to
to
B2.
that, yes. From now to that, if it is B1, for example, if you are going to apply for indefinite leave to remain, you need B1. But
Uh-huh.
it says that it's going to change to B2 from next year, March. So what we are saying that people should not panic at this stage.
Okay.
People should not panic. It says that we advise that as you prepare to apply for indefinite leave to remain, next year, make sure that your preparation is geared towards B2 and not B1 as it is. So if you are not going to make application next year, then you don't have to worry about B2. If you are making application this year, focus on B1. But if you are
Mhm.
going to make application next year and you are writing the exam so that you don't have to write again next year, then it has to be for B2, isn't it?
Okay.
Otherwise, you have
So
to write again once it
yeah, so
changes.
if you would you have B1 and your application would happen after the 26th of March 2027, then you have to worry about B2, not B1, even if you are writing it now.
Exactly. But if you are making the application now, let's say next month, next 2 months, up to 25th of March 2027, you know
Mhm.
that your application would have been submitted. Then you don't have to worry about this announcement. It is not for you.
All right. So yeah, what basically lawyer Asma is helping and understand is that there's been an intention declared really that from the 26th of March 2027, the English language requirement for settlement will move from B1 to B2 across a broad range of immigration routes. BWF solicitors is advising that those applying for settlement after March 2026 must now make every effort to take English language lessons in preparation for the changes. B2 is higher than B1, so obviously you expect it to be a bit more detailed and um, higher level, so to speak, than what it is at the moment. Thank you very much, BWF solicitors. And that's not what they give us in the week, or that's not the only thing they give us in the week. They provide us with the nugget as well. And now another date in 2027. Now they're saying that from 1st of January 2027, an employee cannot be dismissed by an employer after 6 months of working with the employer. Such dismissal may not be fair if the employer cannot prove that it followed due process to dismiss the employee. This one is quoted from Section 25 of Employment Rights Act of 2025. Those of you who have been really following us, you would realize that we've tackled this a bit some few weeks ago, and now there is a date to it. From the 1st of January 2027, an employee cannot be dismissed by an employer after 6 months of working with such an employer. Lawyer, more details, please.
Yes. So for me, it's progress and it's victory for workers, especially workers who would ordinarily be easily dismissed
Mhm.
without due care, support, and attention by the employers simply because they have not worked with the employer for 2 years. And that the employer hides behind the provisions of Section 108 of the 1996 Employment Rights Act, which says that if you are an employee, you can easily be dismissed without any excuse or whatsoever unless you have worked with the employer for 2 years. That was a high threshold protection for employers.
Mhm.
Now, the law is saying that employers' liberty is over. Now it is time for employees to be seen to be human. So that once they work with the employer for 6 months, largely after probation, they cannot easily be dismissed without due care, attention, and reasoning. And the care, attention, and reasoning will be confined within the fact that the employee has a right not to be unfairly dismissed after working with the employer for 6 months. From 1st of July 2026, and the employer, such employee can take action against the employer for such unfair dismissal from 1st of January 2027. So there are two dates here. 1st of
Mhm.
January 2027 is the substantive enforcement date. That is when the employee can take action, can bring an action against the employer at the employment tribunal. And the second date is the fact that if the employer has worked with the employee has worked with the employer for 6 months, Let's do the maths. 6 months to 1st of January will be down from 1st of July, isn't it?
1st of July 2026.
Exactly. So 1st of July 20. So if you see 6 months to 1st of January 2027, it means 1st of July 2026. 6 months will be 1st of January.
Mhm.
And so if somebody is working with the employer today, and by 1st of January, they haven't done 2 years, but the employer is taking action to dismiss them without good reason, the person can bring action because they would have worked with the employer for more than 6 months, right?
Yeah.
And the least is 6 months. So today I am working with the employer, even before 1st of July, then mine is even better. So, and this is the new provision under the Employment Right Act 2025, which is an amendment to the existing Employment Right Act 1996. Section 108 has been amended to become Section 25 in the new law, where
Okay.
Section 108 in the old law used to say 2 years before you can bring action. The new amendment under Section 25 of the new law says that 6 months you can bring action.
Okay. So I have this scenario. Let me see if we could give some good advice to this person, Kende. Kende is a skilled worker working for Happy Care Limited. This person joined the company on the 1st of January 2026. In February 2026, his employer told him that he may no longer be needed after 15th of January 2027. When he asked the employer for the reason, he was told that there have been reports that his behavior towards service users is not good enough. Kende is worried about his rights as an employee should his employer go ahead to dismiss him from the 15th of January 2027. Now, based on the discussion we've just had with lawyers and based on what the new proposition is, let's see if we can advise Kende. Would we say to him, as he has not worked with the employer for 2 years, he cannot challenge the dismissal? Are we going to tell him that as he would have worked with the employer for 1 year, he can bring a claim for unfair dismissal against Happy Care Limited? Or none of the above, he cannot do anything? Think about it. I may be tempted to push it back to Lawyer Asma to help me decipher those one and prefer the right advice, but I'll leave that with you. Try your hands on it, think through it, and see if you could give my friend Kainde an answer and some very cogent piece of advice. We're still live on BWTV and we're coming your way courtesy BWF Solicitors, our trusted partners when it comes to the law. You can visit BWF Solicitors, send to them all your queries when it comes to the law, especially immigration matters. Call them on 0208 493 7340 0208 493 7340. Or you can call at any time during emergency situation 004477 1276 1884 0044 77 1276 1884. Those of you in Ghana, there is an office in Ghana located in Accra. You can call BWF Solicitors and just go in there and make use of their services 055 589 5959. I take that number again 055 589 5959. We're live on BWTV, live on Facebook and YouTube at BWF Solicitors and at BWTV UK. And I know that as our tradition on this program demands, you come in, you announce your presence, and you invite others to join as well. So pick up the link, share, turn on the notification button, and then you will be giving a notification when it is that we put content on our site at BWF Solicitors and at BWTV. Those of you who are here, welcome you and thank you for joining us. We're taking a quick break. When we come back, we'll give you your shout outs and then we go into the question. The question is, am I due for indefinite leave to remain? How do I know? If I do know, what do I do next? Maybe an extension to the set of questions I have posed. Remember, our resource person and guest is Lawyer Charles Asma from BWF Solicitors. You're most welcome if you just joined us. And thank you for sticking around. If you stayed up to this time, there's still more to come.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
BWF Solicitors want to say thank you once again. Those of you on the platform want to say thank you once again and welcome on board. Let's see if I can pick up a few of your shout outs and messages, and then we will move on to have our discussion. Tilly Duma is on and she said, hello, lovely family. Hello, Tilly, how are you doing? And she continues to give the alert that we are on and people should kindly share and comment. And of course, like the page. Thank you. Thumbs up to you as well. And Debbie Obed, good afternoon, everyone. Debbie, where are you calling us or viewing us from? If you let us know, that would be very much appreciated as well. It feels that this is about the first time I'm seeing your name on here. Welcome to the class. Welcome to the family. Share, share, share. One from Nana Ajimai. I call him the class captain. Nana Ajimai, thank you so very much. Thank you for being here and being there for us. The next one we have Franklina Appel. Thanks so much, Franklina. How are you? Thank you, thank you, thank you for being there and sticking with us. How do I know that I qualify for indefinite leave to remain? But Asma, the $1,000,000 question.
Yes, the $1,000,000 question can be answered with a dollar in hand.
Okay, well, that feels very refreshing. Very refreshing. Well, now we're here. We have the question. How do I know, or am I due for indefinite leave to remain? How do I know? Please help us.
Right. So we have different categories of indefinite. By the way, viewers and listeners, a very good afternoon to you wherever you are watching or listening to us from. We've
Mm,
come your way once more, and today's conversation is relevant because a lot of us get it wrong, put in the application only to be told that we are not ready yet. So how do we know that we are ready? And that's the point for discussion.
mhm,
You are applying for indefinite. The first thing is whether your time is due. And the next one is the form to use. Because we are not talking about the formalities, we're only interested in the counting of time or
mm,
the timing. So the timing is relevant because you don't want to waste money and time. Before you qualify for indefinite leave to remain, or you ask yourself whether I'm due for indefinite leave to remain, you have to ask yourself, how did I get here in the first place? How did I get here means what visa am I on? The journey you took, whether it's a bus or train, will determine how fast you get there.
mhm,
And so if it's a bus, you may likely spend more time on the road. If it's a train, whether it's a fast train or slow moving train, again, it may take some time. And therefore, you ask yourself, is my visa the train visa or bus visa or coach visa or tram? I'm using this because we are discussing this for UK and I'm using the context. Because
Okay.
for somebody to apply for indefinite, apart from the exceptions where the person will enter the UK with the indefinite, especially for children, most people would be applying for indefinite whilst already in the UK. And so they would have understood the culture and life in the UK. So they will understand, what do I mean by bus? What do I mean by tram? What do I mean by coach? What do I mean by train? And so on and so forth. That's why I'm using them, just to tell a story to make it easy for listeners and viewers, my students, so to speak, to understand the lesson. So you are on a visa which will take 10 years for you to settle. Then your journey is 10 years, because there are 10 years of stops, so to speak. You are on a train, or you are on a visa that will take you straight on 5 years, no stop, no stop.
Yeah.
Then after 5 years, you are due for indefinite leave to remain.
Right.
Example is, okay, Babuk, I'm going to put you on the spot. We're going to make it interactive. Don't worry. Which,
No,
which of
okay, I'll do my best. Don't worry, I'll do my
Yes.
best.
Which of the visa categories that you've heard about, allow people to hold the visa non-stop, and by the time that they are ready, they are applying for indefinite. They don't have to make any more application. One application will take them to indefinite.
So they would have to go through the 5 year route, family route. They may go through the work permit that will allow them to stay on it for 5 years, and that will lead to indefinite.
Yeah, but
Uh,
these are different. Sorry, but these are different categories of visas. But
yes.
there's one category of visa that is like the fast-moving train, non-stop. Once you get on, you are
Mhm.
on for 5 years non-stop. And after 5 years, straight away, you go for indefinite non-stop. You don't have to make another application in between, non-stop. Think about EU.
So the EU settlement scheme.
Yes, 5 years non-stop, pre-settled.
Yes.
So example is that where the train is non-stop. You sit
Okay.
on the train, by the time you are there, you are ready for indefinite.
Okay.
That is EU pre-settled status, for example.
Right.
So EU pre-settled status is one visa that has no stop. By the time you are making another visa, you will be making
You
an
would have
indefinite
gone the
remain.
5 stops where you are getting off and you get on the bus again.
Exactly, so to speak. So somebody will say, lawyer, I want to make an application. I will ask the person, what sort of visa do you currently have?
Okay.
If the person told me that I'm on a EU pre-settled status for 5 years, I will tell the person that then as soon as the visa is about to expire, you should be making application for indefinite because you don't have to make another visa application to renew it.
Okay.
But that one is non-stop.
Right.
Somebody will tell me that, lawyer, I've been on different visas. I've been a student before. I've done all sorts of rounds. Student visa before, 2.5 before, go here, go there, go there, go there. And I've done that for 11 years now. And the current one is expiring next month or it's expiring some years, a few years to come. Can I apply for indefinite? I would then ask the person within that spectrum of visas,
Mm-hmm.
spectrum of visas, did you ever go on EU visa? If the person says yes, then I have to remove the EU category because the EU category will not be added to the spectrum.
Okay. Because it stands on its own.
Stands on its own. Because there was a change in law where you cannot count EU visa towards the range of visas you can have to get indefinite.
Okay.
But so the person told me that I was say, okay, then if after removing the EU from there, where do you start from? Then the person is okay. I was a student. I got onto masters. I went on to this, onto that. I will also ask the person, did you ever go for postgraduate visa?
Mm-hmm.
And I will tell the person remove the postgraduate visa because it doesn't count towards indefinite.
Okay.
But as long as there was never a break, apart from postgraduate visa and the EU visa, the person can count all other small visas along the way to make up 10 years to apply
Okay.
for indefinite. So you can see that to be able to check the timing, you have to ask $1,000,000 questions
With a dollar in hand.
with $1 in hand to
Mm-hmm.
respond. And the reason is that it's not about yes or no, it's about whether it is true that you are due. So we
Okay.
do what we call counting time analysis. Then we can tell that yes, because the rules say that for somebody to apply for indefinite, the person should have been continuously resident in the UK for 10 years.
Mm-hmm.
But other visas will also tell you that after 5 years, you can apply for indefinite, right?
Yeah.
So the 10 years continuous is not for fast moving trains. It's for the dot trains.
Mm-hmm.
And therefore, if you've been on the dot train with a lot of stops, then we have to count whether you've done 10 stops to be able to move to indefinite.
Okay.
And whether some of the stops count or not. For example, if you have to make 10 stops and you get to the other stop and they say that stop, the train is not stopping there because there's work going on, then your stop cannot count, that part cannot count, isn't it?
Yeah. Because the train is not going back.
It's not going there. So that's the analysis. Very good. So EU, if the train is not going there. Postgraduate, the train is not going there. So you cannot count those ones towards the stops. So the starting point is that for you to be able to qualify for indefinite, depending on the type of visa, you either wait for 5 years and apply for indefinite, or you wait for 10 years and apply for indefinite. Example of 5 and 10. Let's look at the 5.
Okay.
The 5 is where somebody has been on pre-settled status for 5 years. The person can apply for indefinite leave to remain, settled status. Because
Okay.
the rules say that after staying on the 5-year route as an EU national or EU family member, under paragraph EU 14, you can apply for indefinite leave to remain under paragraph EU 11
Okay.
of this EU. So that is for EU nationals. That means if somebody was given indefinite leave to remain, settled status, after 2 years, the person has indefinite leave to remain, and that's it. The person can only be waiting for naturalization.
Mm-hmm.
But today's conversation is not about naturalization, it's about indefinite.
Indefinite leave to
So
remain.
if you were given indefinite leave to remain from day one, then you don't need to worry about indefinite again.
Okay.
But if you're waiting to get indefinite under EU, after 5 years, you apply for indefinite, provided you meet the rules. Then the next one is If you got your 2.5 leave to remain under a British husband or wife, or somebody with indefinite leave to remain, or somebody with EU 5 years, then you have to do, after first 2.5, you have to apply again for another 2.5. And after the second 2.5, you apply for indefinite leave to remain. Because the rules say that under Appendix FM, after 60 months on a valid visa and Appendix FM spouse, you can apply for indefinite.
Right.
So that one, the counting time will be 5 years. And then the person will later look at gaps. We'll look at where there are gaps. Well, so where there's no gap, such a person can apply for indefinite leave to remain in the last month of the 60 months.
In
Because
the
five
last month of the 60 months, is that where we have that 28-day countdown to the end of the duration where you can apply 28 days before it ends?
Very good. So that is how I term it. The last month of the 60 months.
Okay.
Because the last month of the 60 months is taking you to the end. And therefore, in the last 28 days, you can apply. If it's a February month, it's 28 days. If it's a non-February month, it could be 30 days or it could be 31 days. But in the last month
Month.
of the 60 months, if you are on the 5-year route, Appendix FM spouse, and you've done your second, you are in your second 2.5.
Okay.
So we've looked at these two. We also have discretionary leave to remain grant, where the person didn't qualify, but the person was considered based on some good reasons, and the person was given a discretionary visa. Such a person would have been told that after this period, you can apply for settlement.
Mm.
That person wouldn't have to go through the normal long queue. The person will have his or her timing couched out within the visa grant. So
Mhm.
that is also for those people on
But
discretionary
if,
leave.
if you say discretionary leave, in what circumstances do they give that discretion?
So it might be that a person has applied based on health and some other genuine, humane circumstances or
Okay.
reasons. And
Okay.
based on the person's circumstance would have been granted discretionary. So the caseworker will say, oh, okay, take something.
So
Discretion.
if somebody is facing domestic abuse and violence at home, and the person puts in an application based on that, could that be one of those discretionary points?
Such a person will be applying for indefinite leave to remain based on domestic violence anyway, not discretion.
Okay.
Or the person applied for this and they gave a discretionary of something else. And they told the person after this time you can apply for indefinite, then that's
Mm.
also there. But
Okay.
largely under domestic violence, you'll be applying for indefinite if you qualify, if you are an Appendix FM spouse victim.
Okay.
If you are a skilled worker spouse victim, you cannot apply for indefinite. You only have 3 months concession, and you have to decide what you want to do with your life.
I'm so minded to bring us back into the main line, but let me divert just a little. Now we talk about domestic violence. It's often assumed that it happens between a couple. Could children be facing domestic violence, and could they use that discretion as well?
Well, children, I mean, okay, domestic violence
Or abuse?
or abuse, the concept and the policy are geared towards spouses,
Okay.
not children.
Not children.
And so the purposive basis for that policy is to prevent abuse towards partners
Okay.
within the home. Because a genuine parent will not be abusing their child anyway. And therefore, you can't say that I'm a child, my parent is abusing me, so I'm applying for that one. There's nothing like that. If you're a parent, whether your mom or dad is abusing you or not, you qualify as a parent, as a child. so you can apply anyway.
Okay.
But as a spouse, if the person says, I won't give it to you unless you do this for me, that's blackmail. That's emotional abuse. And that is what the policy intended to prevent. And the policy said that such people will be given government automatic settlement so that
Okay.
they become independent from their abusers.
Okay.
So we can see that domestic violence bit is for spouses. So we are not even introducing the children here at all because the policy is not geared toward children. And I haven't come across a child who says that my mom or dad say they won't do the application for me. And so can I do something? That one is really not there.
Hmm.
So yeah.
Okay, all right. So if you just joined us, ladies and gentlemen, we're having a very lively discussion, and we've posed two questions. We're talking about whether you are due for indefinite leave to remain here in the UK, and then the follow-up question was, how do I know? Lawyer Charles Asma from BWF Solicitors is helping us pick these situations and is giving us scenarios where you would be doing the calculation, some straight up from day zero or day one to the 5 years, some where you look at certain circumstances, some where you will eliminate certain things along the route because they don't lead to indefinite and all the other bits. Just before we got to this point, he was explaining the discretionary situation that people are giving the indication that they could apply for indefinite leave to remain here in the UK. That's what BWF Solicitors does. They help us understand the situations, they update us, and of course, they give us the empowerment to be able to put in our applications confidently. And even when they are not granted, they help us make appeals and, of course, right the situation when we have reason to on the side of a law. This is the community and the law, and it's brought to you, as I mentioned, BWF Solicitors, located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them 0208 493 7340 0208 493 7340. In emergency situation, 077 127 61884. Now, earlier on, I gave you the update, in fact, two of them. I will just quickly reiterate them before we take a break and come back to continue with the discussion. The first one was about the English language, and we're saying that from the 27th of March 2027, it's going to move from B1 to B2, from B1 to B2, in fact, from the 26th of March 2027. So if you are preparing to put in an application, that broad range of routes going to your settlement point, you might be thinking of writing the B2 level for the English language. So the advice, as PWF Solicitors is giving, is that those applying for settlement after March 2026 must now make every effort to take English language lessons in preparation for the changes. Update number one. Now, number two was our nugget. And we spoke about another date in 2027. And we're saying that from the 1st of January 2027, an employee cannot be dismissed by an employer after 6 months of working with the employer. Such dismissal, as it says, may not be fair if the employer cannot prove that it followed due process to dismiss the employee. This one is from Section 25 of Employment Rights Act of 2025. So then I posed the question because I had a situation for a friend, Kainda, who is a skilled worker working for Happy Care Limited. My friend Kainda joined the company on the 1st of January 2026. After a month, his employer told him that he may no longer be needed after the 15th of January 2027. When he asked the employer for the reason, he was told that there have been reports that his behavior towards service users is not good enough. Now, this gentleman is worried about his rights as an employee should his employer go ahead to dismiss him from the 15th of January 2027. So I am asking you to think through it and help me advise Kende. Are you going to tell him that as he has not worked with the employer for 2 years, he cannot challenge the dismissal? Are you going to tell him that as he would have worked with the employer for 1 year, he can bring a claim to um, say that it's unfair for him to be dismissed by Happy Care Limited? Or you're saying, well, I don't know, it's none of the above. You can go and find your level somewhere. Think about it. At the tail end of the program, I will be giving you the opportunity to give me what your advice would be. Then we'll run it by Lawyer Charles Asma to see what the best advice would be from the legal standpoint. It's not the community and the law. I'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you for sticking around. And remember, it's still the community and the law live on BWTV at BWF Solicitors and at BWTV UK. Am I due for indefinite leave to remain? How do I know? That's our topic for this afternoon. And we're so privileged to have Lawyer Charles Asma with us, who is helping us to answer these questions. And of course, telling us what it is that we need to look for, how we calculate, and beyond that, what we would need to do. Now, just before we went on to say thank you to BWF Solicitors, we're looking at some of the things we look for to answer the questions we have posed. You talked about discretionary situations. Are there any other forms that we may have to look at?
Right. So we have looked at those aspects. We're also looking at a parent who became a parent who regularized their visa after they had been an overstayer.
Mm-hmm.
Or such a person would have been staying on the visa as a parent of a British citizen or a qualifying child for 10 years. So the person we are looking at continuous 10 years under the 10-year route. And therefore, the last month of the 10 years will be the due date.
Mm.
We're also looking at somebody who was a student, moved to this, moved to this, moved to that.
Mhm.
Removing all the other ones from that would then say that, okay, because the person removed, we have removed all those bits and the EU and the graduate visas that do not count. Counting the ones that count, like student, like skilled worker, like 2.5 as a parent, going to all sort of to be able to accumulate the time. We put the time together, and again, the last month of the expiry of the last visa,
Take that again.
where you have different categories of
Mhm.
visas put
Okay.
together to make 10 years.
Mhm.
You cannot say that the journey is 10 years continuous.
Okay.
Because you have different, you move to bus, you move to train, you move to tram, you move to aeroplane, you walked, all these ones we put together. And therefore, it's difficult to trace the journey to one mode of transport.
Okay.
And therefore, you cannot trace the journey to one mode of visa or one category of visa. So, for such reason, we look at the last valid visa.
Okay.
That will help you to count the 10 years. And the expiry of that date, the last month, will determine whether you are due for indefinite.
Okay.
Let's say you were a student for 4 years.
Right.
You move to another master program for 1 year, 5 years. You got your postgraduate visa, which doesn't count, so that's zero. You got 2.5 as a spouse, 2.5. You divorce your spouse and you had to apply as a parent because you had a baby with another woman.
Mhm.
So bit here. We put all together. At a point, you went to EU. We say EU doesn't count. So the time on EU you have to remove.
Mhm.
But adding all the students, the this, the that count together, because you cannot trace it from student, neither can you trace it from 2.5 as a parent, neither can you trace it from any of them. We have to pull all together.
Mhm.
We realize that the last counting visa is the parent visa, two and a
Mhm.
half. But the 2.5 will expire in 2028.
Okay.
Meanwhile, bringing all the old ones together, your 10 years will be 2027.
Mhm.
Then we can say that 2027, you may be due for indefinite if we do the calculations properly without having to wait.
Okay. But I often say this, and I think I would want to quickly reiterate that it's always best for a layman to give their work for an artisan to do for them. These calculations, as I sit here, my brain is spinning. Would I be right to get a lawyer who is worth their salt to do this calculation for me rather than me sitting back and cracking my brain?
Brakweku, a lot of people ask me this question, lawyer, should I give my work to a lawyer to do for me or I should do it myself?
Hmm.
It's a fair, legitimate question,
Yeah.
but the answer cannot be yes or no. What would the answer be? It depends. Because if
Okay.
you ask me, lawyer, should I eat at home or I should go to the restaurant and eat?
It depends on your pocket.
It depends on your pocket, number one. It depends on your ability to cook at home
Mhm.
and also your preference for home or out, isn't it?
Yeah.
Some people go out to eat because of the ambience. Some people go out to eat because they are fed up with the same food at home. Some people go out to eat because they don't want to make mistake with salt levels. Some people also think that if I go out to eat, I don't know what they are going to add. You know what? Let me just gamble it at home myself. Some people will say that I don't have the money to even, if I can use the same money and cook myself and even save, isn't it?
Hmm.
It depends on your pocket. It depends on your ability to do it yourself.
Okay. But anyway, I'll speak for myself. If I look at these calculations, this one does not count. As a student at a point, it doesn't count. EU, take it away. All that. Listen, I'm saying this right into your face. No lawyer, my viewer out there, go to BWF solicitors at least. Get them to sit you down, explain your situation to them, answer all the questions they will pose accurately, and you'll get a better picture and advise you.
In that case, Bakuku, the second question, or maybe the ultimate question, should be, lawyer, with all the things you've said, is it worth the risk? I would say, no, 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 no. It is not worth the risk. Seek advice. So the question shouldn't be, should we get a lawyer or not? The question will be, is it worth the risk?
Okay.
If you don't have the risk appetite, go to a lawyer so that the lawyer will carry. Sometimes when people come to me, I say, you know what? I will take your trouble and carry. Go home and sleep. When something happens, it is my fault.
Okay.
Then they know that, oh, then that assurance you've given me, I will pay you the money to do for me, and I will sleep and have my peace. And you will have to think and do the job for me. Then it is worth it.
Okay. So when I have thought through, I've done the calculations, and maybe unfortunately I got it wrong. When I put in the application, what happens?
Yes. The other bit we are looking, especially where you say, I got it wrong. And I like the way you put it, I got it wrong. What will make it go wrong is this. Before the change in case law or the law, the rule is that after 10 years, continuously, you can apply for indefinite.
Mm-hmm.
At that time, there was no exception. Whether there was a break or no break, as long as your visa was granted and you have continued on it, to you, you are on the road to indefinite.
Mm-hmm.
Then somebody applied with the same mind, and the Home Office refused them and told them that you have to make up for the difference because within the 10 years continuing period, your visa expired and therefore Section 3C protection was no more. However, you were given the visa anyway after challenging the Home Office. They gave you the visa, but then before you went back to them to challenge them, your visa had expired. And so even though they gave it to you, it doesn't fix the gap.
Mm-hmm.
So the question is, what if there is a gap? There's case law to that. The case of Iyeki and the case of Afzal are clear on the fact that Section 3C is just a shield, not a sword.
Mm-hmm.
A shield in the sense that you can move on with it discretionary. And so there's Section 3C, there's Section 3C and paragraph 39E. Section 3C is a shield and a sword. But paragraph 39E is not a sword, but just a shield. What does it mean? Somebody who had a break would have ordinarily become an overstayer. But because of paragraph 39E, the person was given a leeway and the application was decided and the visa was given, even though there was a break. But at that time, they were relying on 39E, which says that when you have a little break, if you explain to them why, they can still accept your application.
Mm-hmm.
At that time, there was no 3C, or 3C means there should be no break. 39E says that there can be a break, but if you have a good reason, they will accept it. Then, for indefinite, it says that where you relied on 39E in between the journey, you cannot rely on the same 39E for indefinite.
Okay.
And so, where there is a break, you have to make up for the break.
Okay.
And at that point, we don't have to sit back and calculate. Is it time then for the person to apply, considering the fact that within the 10 years, the person relied on 39E? If you relied on 39E, which simply means that there was a break, but the caseworker was sympathetic to give you amnesty, it doesn't take away that there was a break. But the continuous residence for indefinite is where there's no break.
Mhm.
So can you rely on break for indefinite?
No,
No, right?
no.
If no, then Home Office will tell you that because there was a break, you cannot apply for indefinite now. You have to be given another 2.5 to make up for the time or the gap.
Okay.
And that's why those people who make such applications for indefinite, Home Office will write to them to say that we see from your record that at that point there was a break, 10 days, 14 days, or 1 month. The visa was granted anyway. However, because of that break, you are not due for indefinite. So you have to pay the extra health surcharge for you to be given 2.5 until you have made enough time for the continuous 10 years. So
Okay.
that is the exception to the standard 10-year continuous residence rule.
Right. Well, I have tried to ask all the questions. Lawyer has been gracious to explain up to this point. I believe that you may have a question or two. I am going to allow you to put that in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV. You can send a text as well to 07399 208 468. That would also give you the opportunity to send a WhatsApp message, voice note, 07399 208 468. The phone lines to the studio are active now, 0208 493 7345. Lawyer Asma is here to actually pick up your calls and answer them. It could be about this topic we have discussed this afternoon, or it could be any other thing that's bothering your mind when it comes to the law. BWF solicitors, trusted partners, when it comes to the law, will definitely help you answer that question. So get to the phone lines 0208 493 7345. Text 07399 208 468, or leave them in the comment section down below. Am I due for indefinite leave to remain? How do I know? The answers have been given. You may have more, so put them in now. And let me just give you a flash of my social media handles, then I'll continue. Yes, so you know where to go, where to drop the comments, the shout outs, and all the other bits. I asked a question earlier on about my friend W. Obed, and you have responded and you say you're watching live from Boramwood. Charles is your boss. Thank you, W. Thank you so very much. Another person says, I'm so excited to be listening to lawyer Charles. I'm watching from Watford. Always impressed listening to him. Thank you very much, Moreno Ritchie. Thank you for giving us that feedback. Charles Upon, good afternoon to you. Thank you for being here for us. Michael K. Amwa, how long would you take to receive your application? Which application are we talking about? If you could be clear. But lawyer, I dare say that they have the Home Office has a standard and is up to 6 months for most applications. Would that be correct?
Hitherto, yes, hitherto, but that has changed.
Okay.
Now they are saying that the operational standard is no longer 6 months, and that there have been huge operational challenges, and such challenges have impacted on the standard timing. So we now look at a year, and of course, some people get it before 6 months anyway. So I
Mm.
would say that normally when people come to me, when I advise, I say for the duration is between 6 to 12 months.
Well, Michael, that probably answers your question without giving us any further detail. Danladi Cornelia, you're watching with us. Thank you very much. We're picking up your comments, we're picking up your texts, and we also asking you to call if you do have something you'd want to speak to lawyer about. Good afternoon, Kweku and Charles Isaac Ofikisi. Thank you very much. Good afternoon to you as well. Thanks, lawyer, for your explanation. W. Obed says so. W, thank you, and I believe you're okay. 40x Games, watching from Wolverhampton, BWF solicitors, no size. Yeah, obviously. We, we're so proud of that. That's why we're doing this. If a child witnessed the domestic violence, they can be entitled through parent or victim of domestic violence. First, they can apply using MDVAC for 3 months. Before the end of the 3 months, they can apply for indefinite leave to remain. I think King Aibo Khan is trying to put in something to support the discussion.
If a child witnessed domestic violence, can they be entitled through parent, victim, da da da? First, they can apply da 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 da, and therefore they can apply da 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 da. Is that a statement or a question?
Well, I think it's a statement because he didn't put it as a statement. He
Yeah,
said if a child
statements
witness.
are advice to all of us. It's just this person is contributing to the discussion.
Yes, I think so.
Okay. Thanks for
Uh,
your contribution.
Ken, thanks for your contribution. Yes, it makes us a family and a community. God bless. We keep them coming through. My brother came to the UK. That's Charity's question. Came with care. If his wife did not pass her test, can this brother renew his paper?
This brother is holding on to the wife's cloth, right?
Mhm.
So if the wife cannot survive because the cloth cannot cover her up properly, can the husband survive?
Well, the person does not have enough cloth, so you may be in trouble.
And so the question is, so this question is, my brother's wife is in trouble, and my brother's wife is the one covering my brother. If my brother's wife is in trouble because the visa cannot be renewed, will my brother be in trouble? What is the answer? It's obvious, isn't it?
It's obvious, yeah.
It's obvious. And that's why I didn't go yes or no. It's obvious. So the only
Hmm.
way to get around it is either your brother moves on to find his own solution, or he holds on to your sister, the wife, to make sure that they are both safe. That means he should help the wife to pass the exam.
Well, help. I didn't say go and do it for them.
Help
Yeah.
means learning with her, preparing her, and
Mhm.
making sure that she passes. Otherwise, they are both in trouble.
0208493735. Text 07399208468 or leave them in the comment section down below. Either on Facebook or YouTube at BWF Solicitors and at BWTV UK. One here saying, great show, watching live from Hammersmith. Thank you very much. We appreciate you so much. Moving on. Yes, let's see. If Minifia says, what options do overstayers have when you have overstayed? What option do you have?
And overstayers options. We've done lots of videos on this, but I'm going to keep it simple, straightforward. As an overstayer, you have option under human rights
Mhm.
to regularize your stay. Such options are limited to one corner. The corner is where you are a parent. And you are a parent because you have a child who is British or who has 5 years EU or who has 5 years who has indefinite EU or who has lived in the UK for 5, 7 years. That is as a biological parent.
Mhm.
Or you become a step parent for a child, the same category of child or children. This time, your husband that you are married to has a child with another woman, but they didn't marry. And so the man lives somewhere. The child spent time with the man, and you are living with the man as new wife. And so anytime the child comes around, the child depends on you being the stepmother. That is a way to apply based on your stepchild. Otherwise, there's no other meaningful option.
Well,
And
if
of course,
you,
and of course, and of course, Brad Koku, the
yes,
last one will be that I know this wouldn't apply to this person, but because the question was open, let's add this open one. Where the person has been an overstayer, they've lived in the UK for 20 years, then they can apply under private life, paragraph appendix private life, paragraph PL 5.1A of appendix FN. Sorry, appendix private life.
okay. Right. You see, sometimes when you knock on a door or you have a key slotted in a door and you open it, it opens another person's door as well. Your answer has provided some extra benefit for people who may have situations and a bit beyond what you have. Keep them coming through. Comment section, Facebook at BWF Solicitors and BWTV, and YouTube, same handle at BWF Solicitors and at BWTV. Um, COS employer cancelled but still doing 20 hours elsewhere. What are the options, lawyer?
COS employer cancelled,
Mm-hmm.
but still doing 20 hours elsewhere.
Yeah.
So the first question is, after the COS employer cancelled, has this person been served with 60 days notice? If yes,
Mm-hmm.
is the 60 days over? If yes, does this person still have a visa? That's one layer of point.
Mm-hmm.
The second layer of point is, after the COS cancellation, has the employer's license been cancelled or revoked? If the license is not revoked, has this person sought a new employer? If no, can they find new employer to be able to move on with their lives, having obtained a new employer and a new visa within the same industry?
Mm.
For the 20 hours, obviously you have 20 hours because your visa is valid. But if your visa is no longer valid, then on what basis are you working 20 hours anyway? And
Mm.
this person, if it's an overstayer, the answers are the ones we've given. If this person is not yet an overstayer, then they can switch to another employer or switch to new family life and apply through their new dependent or new spouse.
Okay. Well, Voti X Games, thank you very much for that. Keep them coming through. We're picking them from the comment section and from all the other platforms as well. Jennifer comes in, says, "Good evening, lawyer. Um, my cousin wants to invite her aunties and uncle over to attend her wedding. She wants to know what the requirements would be for such an invitation to be valid, really."
Okay, right. One, you have to ask yourself, what are the parents of this cousin? And why is the cousin inviting aunties and uncles instead of parents and siblings? It's
Mhm.
important.
Yeah.
Commonsensically, why will you be inviting your extended family members to your wedding whilst your parents and siblings are there? And number two, why will your aunties and uncles be attending your wedding? Yes, they are family members, but can they not choose to observe remotely? Number three, what shows that these uncles and aunts will return home after the event?
Mhm.
Number four, who will be sponsoring them? Number five, how do you link or connect to prove that these are your aunts and uncles. And number six, what shows that when they come, they will go back. If you're able to answer all this correctly, then there is a chance. The requirement is under paragraph V 4.2 of Appendix Visitors, which says that a visitor to the UK must be a genuine visitor. They must prove that they will return to their home country after the event, and they must show that the event is one that is genuine.
Mhm. Evidence is the name of the game. So, if I want to prove the genuineness of the wedding, for instance, would invitation cards be suffice?
Of course, invitation card is the wedding, the evidence that something is happening. So that's the
Mm.
purpose of the event, or which will have the date and all that. But can the event go ahead without you? And that's the dollar question.
Mm. Okay, well, obviously, you need to answer those questions and answer them to convince the caseworker that they should give you, or the entry clearance officer, so to speak, that they should give you the visa, or they should give your aunties and uncles the visa. 0208 comment section at BWF Solicitors and at BWTV. And of course, text 07399208 468. Kwame Lewis is here, and I am a skilled worker with my dependent wife and child. My visa will expire in December 2028. I heard that by July 2028, the care visa will be abolished. What are the opportunities available for my family and myself? Um, yes, Lord.
So, breaking it down, I hear that July 2028 is the last for care visas and that the program will be abolished. What do? I am already here and my visa will expire December 2028. Well, you are here, your visa will expire 2028. Whatever you heard, I don't think it says that all those who are already here will be removed from the UK. You are already
Mhm.
here. If the program is going to be abolished, it's only going to be abolished, and those who are yet to come in are the ones who will be affected. You are already in. So if your visa is expiring in December 2028, make sure you are still with the employer or you've moved to a new employer so that you can renew your visa and continue.
Thank you, lawyer, for that answer. Kwame Lewis, that's the bit for you. Remember, from the 1st of January 2027, it may be unlawful for any employer to dismiss an employee based on the fact that they have not worked with them for more than 2 years. And it says that an employee cannot be dismissed by an employer after 6 months of working with the employer. Such dismissal may not be fair if the employer cannot prove that it followed due process to dismiss the employee. This one is quoted from the Section 25 of the Employment Rights Act of 2025. Again, also remember, from the 26th of March 2027, the English language exam that you have to take will have to be at B2 instead of B1 for most of the immigration routes. So remember, it's now B1, you'll move to B2. So the advice we're giving you is that if you're applying for settlement after March 2026, you must now make every effort to take English language lessons in preparation for the changes. I have this as well to help my friend who is in a tight corner, so to speak. He's a skilled worker working for Happy Care Limited. He joined the company on the 1st of January 2026. In February 2026, his employer told him that he may no longer be needed after the 15th of January 2027, When he asked why, he was told that there have been reports that his behavior towards service users is not good enough. Now, he is worried about the rights or his rights as an employee. Should his employer go ahead to dismiss him from the 15th of January 2027? What advice would you give him? Would you say to him that as he has not worked with the employer for 2 years, he cannot challenge the dismissal? Are you going to say that he would have worked with the employer for a year? He can bring a claim of unfair dismissal against Happy Care Limited? Or, well, kind of, as none of the above, I can't give you anything. Would that be your advice? Think through this, taking a break. When we come back, we'll still be with Lawyer Charles Osama, but I'll be expecting you to give me answers to this one. So it's either one, two, or three. And if you still have any further question, you can put that through the platforms, Facebook, YouTube, at BWF Solicitors, at BWTV UK, and via text 07399 208 468. I'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, welcome back, and thank you for sticking around. I do really appreciate. So, if you have stayed on with us up until now, then I think I deserve your liking of the page. Thank you. Please do it for me, and I'll make my algorithm look right and good. Last milestone here. Daniel J has come in with this, and he's asking that he started his skilled worker visa from the 21st of July 2021. The question is, when can he put in his indefinite leave to remain? He's a registered nurse, lawyer.
So, as I said, for skilled workers, you know that after 5 years, you can apply for indefinite leave to remain.
Mhm.
Again, 21, 22, 23, 24, 25, 26. That will be July 2026.
Mhm.
We know there is going to be a change from April 2026. We don't know whether it's going to affect nurses or not. So if it doesn't affect nurses, then the person has from June 2026 to apply for indefinite, because June would have been the last month
Month of the
within of the
60th.
5 years.
Okay.
Yeah, the last month of the 60 days or the 5 years. But if the rule is made in April to say that all those who are on skilled work expecting to go for indefinite after 5 years, this is how you are going to be delayed, then the person cannot make an application. And so the answer is yes, you can apply if you're a nurse and you're on a 5 year route, 5 year skilled worker route. You apply by June 2026 when you have 5 years, 1 month to go to end the 5 years visa. However, if there is a change, then that may affect you. And so the answer is on the condition that no new change is made to affect you as a skilled worker.
Hmm. Well, if you have any question, let us have it while we still have time. And then I think probably after this one, we will be going over to pick up your advice that you gave in my friend Kainde. Um, Kwabnat Rovam says 10-year route. By the time I do the last two and a half, I'll be left with 10 months. Do I apply for the two and a half, or is there something else to do? If applying, do I pay the full 2.5 years? This one, a lot of
Okay.
calculations in there.
So yeah, 10-year route. So here, if the person can prove that there has been Section 3C protection throughout, that means there is no gap at all, which might have taken the person from 3C to 39E.
Mm,
In this case, the continuous residence will count from the very day he had the first two and a half. And any delay would have been caused by home office delay, which cannot be used against him. In this case, his 10 years will not be when the last visa expires. It will be when the clock hits 10 years from the first two and a half. And so the person can go ahead and apply, even though the visa will expire 8 months later. Is it 8 months later? He said 10 months later.
10
Yeah, he
months.
can still go ahead and apply once 10 years is set. And the next question is, do I apply for two and a half, or there's something I think I've explained? You don't
Mm,
apply for two and a half if you think you have met all 10 years
all
without
10
break.
years.
If applying, do I pay full two and a half? Why will you pay full two and a half? Or I mean, if you are applying for two and a half, well, if you don't have to apply for two and a half, then you don't have to pay for two and a half. But if you have to apply for two and a half because you are not yet due for indefinite, then you pay for the two and a half. Even though you've paid the money to them for indefinite, in your case, you are lucky. If you pay the money to them for indefinite and they come back to tell you that no, you have to get two and a half, they will ask you to pay for the IHS fee to top up because the total is without indefinite, you would have paid 3,910. With indefinite, you have to pay 3,029. So normally what happens is that somebody would pay 3,029 for indefinite leave to remain application. Then they will tell the person that you don't qualify. And so we are giving you two and a half, but you have to pay for the IHS.
Mm.
Then you have to pay for £2,587 50 pence for the IHS. Later, they will have to refund you the difference between the visa fee of 1321 and the 3,029 that you paid.
Well, I'm going to my friend lawyer to see if we could prefer some cogent advice because he says that from January 2027, he would not have his job. And would he be able to bring a case of unfair dismissal based on Section 25 of Employment Rights Act of 2025? So, my viewers, please help me. Let's see what advice you would give to Kainde. Um, if we could get a question on it. Yeah. So, yeah, it's a skilled worker working for Happy Care Limited, joined on the 1st of January 2026. In February 2026, it was told that after 15th of January 2027, because there have been reports of his behavior towards service user not good enough, he will not be allowed to continue his job. Now he's worried about his rights as an employee should his employer go ahead to dismiss him from the 15th of January 2027. What advice are you going to give him? Um, as he's not worked for 2 years, he cannot challenge the dismissal, or he could still go ahead and challenge it because he's worked for a year at least, or none of the above. What are your answers? Let me see. Let's see what we have from Anita. None of the above. You're not sure as I am sitting here, I guess. Okay, let's see. Gabriel Anson says, as he would have worked with the employer for a year, he can bring a claim of unfair dismissal against Happy Care. Okay, thank you. Sorry. Kofi Asiedu says number two as well. Thank you, Kofi. Moving on to the next one, we have Patricia Pokia, who's also not sure like myself. Number three. Okay, well, let's see who else would help profess some advice. Peter also says none of the above. You have not worked 2 years and you've worked for a year. You can't do that. Minister Champoma thinks that he has not worked with employer for 2 years, so he cannot challenge the dismissal. Right, thank you. The next one is Isaac J. Isaac thinks that he would have worked for the employer or with the employer for a year, so he can bring a claim of unfair dismissal against Happy Care, which is threatening to sack him. Sally Adai says number one, he has not worked with the employer for 2 years. Ohimecha also thinks that he's not worked with the employer for 2 years, so he cannot challenge the dismissal. Henry Morgan also thinks that yes, he's not worked for 2 years, so he cannot challenge the dismissal. Jacqueline Asante, none of the above. Jacqueline, none of the above. That's what he said. Philip Kisi says number two, as he would have worked with the employer for a year, he can challenge it. Priscilla Boateng also thinks yes, it's number two. Let me take the last one and I will seek refuge. I love this. I want to keep this on until we have had the correct answer. He should change his conduct and character before 2027. The employer and clients might have some good recommendations. Lawyer.
He should change his character and conduct.
Yes.
The
Before
employer and
2020.
the employer and client might give good. I mean, well, at the end of the day, the employer he says that you see what the employer is saying is that Kehinde. Okay, what did the employer say when he questioned the employer?
The employer said his behavior towards service users is not good enough, and those are that's reports coming to
That is
to the employer
report.
really.
That is a report coming to the employer. The question is, has the employer tested the evidence about the report to
Mm-hmm.
confirm that this is a genuine, believable report?
Yeah.
If not, if the report is not true, then what is there to change about his character?
Well.
Yeah.
um, YR4166. I wish I could put a name to that, but yeah, that's your handle. If the report is not true, what character is he changing? maybe I'll put that in the third category, none of the above.
No, no.
But lawyer, what would be the best advice based on the act? What would be the best advice we give him?
Okay, so let's go through the options.
Yeah.
Does option one say? That because he hasn't worked for 2 years, he
Mhm.
cannot do anything. But we are looking at the timing. We are told that the employer intends to dismiss him in January 2027.
15th January.
Yeah, January 2027, and
Mhm.
specifically 15th of January.
Yeah.
But we are told that the employer, I mean, somebody is saying that, well, Kehinde hasn't worked with the employer for 2 years, so there's nothing he can do. But let's be mindful. If we are talking of 2027 January, then new law may be favorable to Kehinde. In
Mhm.
this case, he doesn't have to have worked with the employer for 2 years. The 2 year threshold is only for the current law, which is the Employment Rights Act 1996, Section 108, says that 2 years. But the new law, which will start from January 2027, says that you don't have to work for 2 years. You only have to show 6 months.
Mhm.
So, if that is the case, then the 2 year advice is not reliable or genuine because it is no longer 2 years, it's 6 months. So one is out. We
Okay.
go to number two. Somebody is saying that, oh, Kinde can what? Will be able to bring action against the company because at least by January 15th January 2027, when they want to dismiss him, he would have worked with the employer for 1 year. Is it true? He started working with the employer for February 2026, right?
Mhm.
And therefore, by January 2027, when they want to dismiss, he would have worked with them for nearly 1 year. And
Yeah.
if he's worked with the employer nearly for 1 year under the new law, which will start from January 2027, he cannot be dismissed because he would have worked with the employer for at least 6 months.
Yeah.
And so working with the employer for 6 months gives you leverage which wasn't there before, but is going to be there now by the time they want to dismiss him. So he can rely on the new law to say that I've worked with you for at least 6 months, and in my case, almost 1 year. Give me a good reason why you think people are complaining about me, and you, my employer, you haven't sought to advise me, you haven't sought to train me, you haven't sought to take me through the process, and all you can do is to rely on flimsy reports from people to dismiss me. You have a claim to bring against the employer at the employment tribunal? The answer is two.
The answer is two. Yes, he has worked for 6 months from that, and he's worked from the um, 1st of January 2026. So, as lawyer has explained, the from the 1st of January, an employer cannot dismiss an employee who has been employed for 6 months from the 1st of July 2026 without following procedure for dismissal. Therefore, he can bring an action for unfair dismissal against Happy Care Limited. And that's based on Section 25 of Employment Rights Act of 2025. Next week, we will be looking at another scenario. And then when we have a case study like that, we'll bring it up. Um, Thank you, lawyer. You were thinking that the person should change his behavior, right? It has to be proven that he's done something wrong, and there is fair reason for him to be dismissed. Other than that, he can be dismissed like that. Laws work. Well, Laura Johnson Smart, yes, this afternoon I posed two questions. Am I due for indefinite leave to remain, and how do I know? And you helped us answer both of them. Can you just give us a brief summary as to what you'd said?
Yes, so to know that you are due or not due depends on the journey you have embarked on and the
Mhm.
route you are on to settlement. Depending on your route to settlement, you have to stay for 10 continuous years on the visa or different visas, or 5 continuous years on the visa.
Mhm.
Therefore, if you are staying on a visa for 5 continuous years, then yours will be 5 years to indefinite, and you'll be due the last month to the 5 years expiring. If yours is based on 10 years, you'll be due the last month to the 10 years expiring. But
Mhm.
if there had been a break in either of the two categories, and you were exempt, you were still given the visa when you were due for renewal, then you have to make up for the break because the break does not protect you towards indefinite. It only protects you for the renewal, not indefinite. And so, where there is a break in the continuity of the visa, whether 5 years continuity or 10 years continuity, the break will have to be made up for by further limited leave to make up for the full 10 years continuous residence of 10 years or continuous residence of 5 years. This is what we came up with in terms of whether you are due or not. And how do you know will be for you to sit and calculate from the beginning you were given your first valid visa up to the point you are aiming for the settlement, and whether there was any gap in between along the way as you kept renewing your visas. If no, then you are not due. If no, then you are due. If yes, then you are not due. Still, if you are not sure, what you have to do is to look for the first visa you were given, whether 2.5 or whatever, and check whether when you were renewing it at any point in time, there was a break. And this is how you work it out to be able to know whether you are due or not. In case not sure, please get in touch with a lawyer who will work with you to calculate the time for you so that you'll be confident that you are now due or you have to wait a little longer.
That was lawyer Charles Asma, and that was on behalf of BWF solicitors. We have had very cogent answers to the both questions I posed at the beginning of the program as part of our topic. Am I due for indefinite leave to remain? How do I know? Those were the answers. I believe, as he said, if you have any further questions, I would recommend that you speak to BWF solicitors. They are located on the fourth floor of the other house. 214 to 218 Tottenham High Road, Seven Sisters in North London. Call them on 0208 493 7340 0208 493 7340. In emergency situations, you can call 077 127 61884. And it brings us to the point where we draw the curtains now on another wonderful edition of the Community and the Lord, brought to you by BWF Solicitors. First of all, thank you to Lawyer Charles Asma for spending time with us and empowering us. To BWF Solicitors as a family and a firm, thank you so very much for the opportunity and the chance to do this with our community. And to my producer, Professor Day, thank you for your loyalty and, of course, your diligence to work. And to Shilankra and Padma Dodu for the production behind the scenes. Kwaku, you have been a faithful servant to BWF Solicitors. You deserve a golden medal. Well, I love the community. That's why I do this. And thank you very much for supporting as well. Keep supporting, spread the news, get people to join us as we do this every Saturday. We're coming back again, same time next week. Until then, be good.